Hello, everyone. My name is David Rosengard. I'm a managing attorney in the Animal Legal Defense Fund's Criminal Justice Program, and I am delighted to be joining you for this year's National Justice for Animals Week, and specifically being able to talk with y'all about wild animal crimes and crimes against wild animals and what the distinction between those are. I'm going to try to keep my remarks fairly brief because if memory serves, you are probably on lunch break during law school, and you probably only have half an hour or 45 minutes to watch this video, grab some food, hang out and talk with the rest of your student Animal Legal Defense Fund chapter. So without further ado, we will launch into this. Um, it will be an exciting discussion. There will be at least one Viking and at least one critical piece of case law that you probably remember from your first year 1L experience. And in fact, we'll start with those because what better way, if indeed I can get the video to click forward. There we are. So let's talk about the history of wild animals in the law, because we have a lot of history here. Wild animals feature in Anglo-American law, the body of law from which the common law and then American law derives from a very early moment. In fact, we can see this going back to King Canute, a Norseman who was in the process of busily ruling what later would become England in the early thousands. And having seized control of England, the king thought to himself, what better way to get these English people, these native folks, to sign on to my rule than codifying the law. We'll write the law down, we'll get it settled the way I'd like it, and we'll figure out a way to incorporate the views and traditions of the people of the Isle. So surely they'll be very happy about being ruled by me, King Canute, a Norseman from across the sea. And so to do this, he gets prominent community leaders together at a Witan, a gathering in Oxford, and he has them start to codify what we would call common law. And a certain portion of that common law involves what access people have to wild animals, who can hunt, how they can hunt, and the process by which you resolve this. Um, Now, King Canute's schemes to set up a dynasty ruling England don't ultimately bear forth in the long run because, well, in due course of time, there are further people going about conquering England, most notably William the Conqueror at the head of a Norman force. William, similar to King Canute, also has this notion that this is a fine time to start codifying law, writing things down. And specifically, he creates a body of law that incorporates what is known as forest law. And these laws focus on wild areas of England, specifically forests held by the crown and the animals therein. Now, biographers of the day describe William the Conqueror as a man who loved animals. He's described as caring for them as he would his own children. But if you look at forest law, his concern mainly seems to have been who would be able to hunt them, and more particularly, trying to ensure that he would get to hunt the ones he really cared about and other people wouldn't. So, royal forests would be the preserve of William, other members of the royal family, his court, and certain animals would only be huntable by William and his designees. What this says about William and his feeling towards his children or his child-rearing techniques, I leave as an exercise for the listener. But it does certainly point to one of the ways that wild animals and humans and legal relationships exist in tension with each other. There's a tension between animals in the wild being treated as their own beings with their own interests. There's a tension between them being treated as the property. We'll talk about what that might mean, but the property of the state, whether the state is literally the crown or whether it's a larger, more modern government. And a third point of tension is animals as property or somehow connected to a community interest. So we've got animals as themselves, the kind of creatures that you need to go and hunt because they're not going to just let you catch them, kill them, eat them, and whatnot. Animals as the property of the state, and animals as being a focus of community interest. And this sort of legal tension with animals is not limited to the British Isles by any means. Uh, Not to give you flashbacks to your 1L property course, but you may recall Pearson versus Post. It's New York, 1802. Lodwick Post and his friends are chasing a fox. Jesse Pearson sees the fox, kills the fox, and takes the fox, and then everyone ends up in court arguing about whose property that fox is. Or more specifically, in property law terms, do you actualize your ownership interest at the chase or the catch? This reaches what at the time was the New York Supreme Court of Judicature. A group of luminaries are involved in the case. Post's attorney will become the mayor of New York in the future. Pearson's attorney will be a chancellor of New York in the future. The judges include a future federal Supreme Court Chief Justice, a future federal vice president, and James Kent, who writes some of the early influential treatises on American law. The outcome of this case, in property terms, of course, is that you get the animal when you capture them. Uh, but for our purposes, looking at the animals themselves, it's a way to really underscore that animals are different, even when we're talking about property. They move about on their own. They make decisions on their own. These are autonomous creatures. And that's particularly true in some ways for wild animals because they're doing what they want to do without, presumably, any guidance training from humans. And so this is a good moment for us to unpack the legal status of wild animals. You've probably heard, and it is accurate, that animals have property status throughout the United States. But it's important when we're talking about wild animals in particular to dig into what kind of property animals are. And here I'm going to draw a distinction for you between proprietary ownership and sovereign ownership. Proprietary ownership is what most of us are familiar with. It's the way you might own an object, like this smartphone that's helping me keep track of how long I'm talking so I don't run us over time, or a pen, or a car. It's the way we tend to opt to deal with ownership and property interest in our everyday life. And then you've got sovereign ownership, which is the ownership that a nation or a community might have over resources, communal interests. It's less about owning something in the physical and more about being able to designate who has access to that piece of property. And which category wild animals fall into has shifted over time. And the key cases you're going to want to look at here are Greer versus Connecticut out of the late 1800s and Hughes versus Oklahoma out of 1979. Greer comes down in the proprietary ownership sphere, arguing that wild animals are literally the property of not only the state in terms of the government, but literally of individual states, i.e., the states making up the United States of America. And as such, Greer really leans into letting each state own, in a very real property sense, the individual animals living in the wild within that state, which has some pretty significant implications for who can decide when you can hunt those animals, how you can hunt them, where those animals go, and so forth. In contrast, Hughes versus Oklahoma, the modern reading of this, firmly sides with sovereign ownership. The idea is that the government, the community, can determine who can take an animal, to go back to Pearson versus Post, who can acquire ownership by capturing them, but the government, the community doesn't own the animals in that real property sense. that the capturer, the taker, might. Incidentally, this removes ownership from the states and allows the federal government to regulate animals much more solidly under the Commerce Clause, and thereby really shifts the federalism balance of wild animals in American law. Now, a third way of looking at property status for wild animals is the public trust doctrine. The notion that certain properties, certain resources are held in trust by the community for future generations. And the community, in the form of the government, has a responsibility to not degrade or dissolve those resources, those public amenities, uh, so that they're still around in the future for future generations. Um, all of which is to say that wild animals are certainly susceptible to being property, but whether they are actually property is going to depend a little bit on what kind of property you're talking about. Wild animals, of course, have other relevant legal statuses. And I like to illustrate this by our example of this mouse in the lower right-hand corner of the slide. Uh, the same mouse, depending on how they're situated in relationship with humans, could have a lot of different overlapping legal statuses. That mouse could be on exhibition in a mouse circus, perhaps, or a zoo. A mouse could be a research subject. A mouse could be a legal vermin or pest. A mouse could be a food source for other animals or even for humans. A mouse could be a companion animal, a beloved friend or a member of a family. And the mouse could be legally an endangered or threatened animal. And all of those statuses can be true while the mouse is also a wild animal and property, or at least susceptible to being property. How exactly the mouse is going to be positioned legally, therefore, and how wild animals in general are positioned legally, therefore, really hinges upon how those different statuses can overlap. And also, of course, we need to know which animals are wild. I promise you, this is not simply an opportunity to show you some delightful art from where the wild things are. The law doesn't always clearly define what a wild animal is. If you have a well-drafted statute, then congratulations. You'll have some information in your state law that delineates with some clarity which animals are wild and which animals are not. But that isn't going to be the case frequently. And so you may end up having to argue or dig into which animals are going to be wild. And these are a few common ways to approach that. One is you determine who a wild animal is based on whether or not they live in the wild. And commonly, this is constructed as an animal living without human support. But we have urban wild animals, coyotes, raccoons, squirrels, rats, mice, and others who live amongst humans and who feed on human trash, human garbage. Without that form of perhaps unintentional human support, they wouldn't be living or surviving in the places they do. We also have captive wild animals, lions, tigers, bears, zebras, monkeys, and so forth, who live in zoos, who live in private hands, who live in exhibition venues like circuses. And it would be hard to argue that those animals are not wild, even though they aren't living in the wild. They aren't living without human support, human control. So another way to define wild animals by an animal that acts wild, i.e., an animal that is unaccustomed to or ill-disposed to human interaction. But we also know there are wild animals who become tame. So do they stop being wild? Uh, a third option would be to flag a wild animal as an animal that is genetically wild. And you might define that according to their DNA. You might define that according to whether the animal, the species has come into being without selective breeding. But this becomes difficult because animals interbreed. Let's take canines, for example. Dogs and wolves can interbreed together, and domestic dogs and wild wolves are not usually terribly concerned about whether that cute wolf or cute dog over there is domestic or wild. Their interests are in reproducing. And so as a result, in continental North America, it is increasingly difficult to find a wild wolf without some canine domestic DNA somewhere in their genetic mix. But those wolves are no less wild animals. And all of this is leaving aside the feral animal problem, the problem of animals that are from domesticated species, but who have lived and grown up unaccustomed to human interaction, who are not tame, and who live as much in the wild as some wild animals do in urban settings. This can be a problem for the law if your law delineates between domestic animals and wild animals, but doesn't hold a space for feral animals. Texas had a fairly infamous line of cases a few years back because at the time, Texas's animal protection law included animal protection law for wild animals and protection law for domestic animals. Didn't have any protection law for feral animals because domestic was defined in such a way to not include feral animals at large. And so there were a number of cases where people committed what would be acts of animal cruelty against feral cats and successfully defended themselves on the ground that those feral cats were not wild animals, but they also weren't living with humans. They weren't the property of a human. They didn't fit the, at the time, operative definition of domestic animal for Texas. Since then, Texas has modernized its definitions of animals to clearly indicate that feral cats and dogs, for example, are protected in the same manner as other cats or dogs. But that's an important distinction to look at when you're examining your state's wild animal laws and your larger animal protection laws. Which animals are going to count as wild? Which animals are going to count as non-wild? And do you have a slot to fit feral animals into? So moving to wild animals and crimes, with the footnote that your individual jurisdiction will give you the relevant law to determine which animals count as wild animals. There are a few types of crimes that implicate wild animals. Uh, the first are resource crimes, or as I like to think of it, unhand the people's duck. These laws are around treating wild animals as resources that the state or the community has the authority to regulate. So poaching laws or hunting laws are great examples of these. These are laws that aren't about protecting the animals as sentient, living, feeling creatures, but protecting them as a resource that the community gets to regulate who and how they can be used. Some laws are focused on environmental and species protection. Um, the Endangered Species Act is perhaps the most iconic of these in the United States. And the focus here is less on the individual animal's experience and more on the impact on the environment or the species as a whole. This isn't to say that harassing or injuring or killing an endangered animal or an animal protected, for example, by the Marine Mammal Protection Act won't trigger a violation of the law. It's simply to say that those laws as a focus are looking at and directed towards the health of the species as a whole, typically, and look at individual animals as elements of that species. Some wild animal crimes have required predicates. Typically, these are trafficking crimes. Um, one of the most notable in the United States is the Lacey Act, that effectively makes it a crime to traffic an animal that's been illegally taken in one jurisdiction into another. And then there are crimes that focus on the animal's experience. Did this animal suffer abuse? Did they suffer neglect? Were they fought? And so forth. These are classic animal cruelty crimes. And of course, you can get both. The Marine Mammal Protection Act, which I alluded to earlier, has a take provision that's broad enough to cover both a lot of classic cruelty and that speaks directly to activities that would harm the animal as the member of a species. So really quickly, non-cruelty crimes. All of these crimes other than the ones that speak directly to the animal's experience. Why are those crimes there? Why have we defined them as criminal acts? Largely, we've defined them as crimes because we are looking to deal with issues of property, utility, and the commons. So looking at animals as belonging to someone, as having utility in terms of their impact on environmental health or in terms of them being lovely to experience when we are outside walking around the world, taking in the wild world around us, or out of a notion that they are a common good. Again, this really resounds in the public trust doctrine. Um, and it's worth thinking about here whether these are malum in se crimes or malum prohibitum crimes. Malum in se crimes are crimes that are actions that are criminalized because they are inherently wrong. They cause an inherent harm. I would argue that crimes focused on preventing extinction are malum in se. The inherent harm is that you are driving a species to extinction. Whereas malum prohibitum crimes are things that are illegal just because they're against the rules, but not necessarily because of any harm involved. So hunting where everything you're doing is lawful except you don't have a valid license would be malum prohibitum because the harm an animal suffers there from being shot or trapped or fished out of an ocean or a river isn't the crime. The crime is that you didn't have the right piece of paper. And that is a regulatory crime. It's a crime that's against the rules, not something that's a crime because it actually caused harm. And this gets to whose interests are being vindicated by these crimes. Certainly for the malum prohibitum crimes, I would argue that the state and society's interests are being vindicated. Again, hunting licenses are a great example. What's being vindicated there is society's ability to regulate when and how someone can acquire property interest in a wild animal by capturing that wild animal. Uh, we might be vindicating the interests of animals as a species to the extent that we're criminalizing acts that would imperil that species as a whole. But we're not at this point really vindicating the interests of individual animals. For that, we need to get to the cruelty crime level. Um, and modern cruelty crimes really are malum in se crimes because they're about the animal being protected on their own merits. If we go back to earlier moments of American history, we can find some older vintages of cruelty crimes that are about protecting animals as property. This would be an example of an era where it would be lawful to beat your own horse, but not lawful to beat someone else's horse because you would be damaging that other person's property. Or it might be lawful to beat your dog at home, but not in the street because it disturbs the peace. At this point in American law, animal protection law, animal cruelty law really hinges on whether an animal experiences, for example, an injury or a degree of suffering, a certain level of harm. And so that's inexorably wrapped up in the animal's experience as a sentient creature that it can experience pain and suffering or happiness and pleasure. And it's about the government, about society saying, we feel that animals have the right to be shielded from unlawful suffering at human hands. We can have a debate about how broad unlawful should be and what degree of responsibility humans should have. But clearly, when we're talking about protecting animals based on suffering or injury in the modern cruelty context, we're talking about a malum in se crime that vindicates the animal victim's interest in not being subject to criminal cruelty at human hands. Um, and it's important that this exists because these non-cruelty animal crimes wouldn't capture all of the relevant conduct that we're trying to address. It wouldn't, for example, capture causing suffering and injury to an animal if it didn't fall into these other categories. So, a brief aside on cruelty crimes. My apologies for those of you who have already taken animal crimes classes, but this is going to be useful as we dive into the next, we've got 14 and a half minutes left, the next 14 and a half minutes of what we're going to be discussing. So, let's start by acknowledging that there is a wide range of animal maltreatment. Animal maltreatment is simply negative things that humans do to animals. Some animal maltreatment is criminalized, and that is animal cruelty. Animal cruelty consists of a number of subcategories. So we have acts of commission, i.e., animal abuse, things someone is proactively doing to an animal that are criminal. We have acts of omission, i.e., animal neglect. The distinction there is an act of omission is failing to do something for an animal that you had a responsibility to. You can't omit a responsibility to an animal that you don't have any responsibility for. And typically, animal protection laws in the United States give you responsibility for an animal based on having custody of that animal, control of the animal, or ownership of the animal. So often humans are not set up to have the sort of responsibility over wild animals that would allow them to commit acts of omission against them. Whereas almost always humans have the ability to be liable for an act of commission against a wild animal. So I'll give you an example. If you are out for a walk and you see a bunny by the side of your path, and that bunny is emaciated, looks like they're starving, you typically don't have any responsibility to feed that rabbit, to get them medical care, to rescue them, to provide them with water, or do anything else because you don't own that rabbit. You don't have custody or control over that rabbit. You can't neglect that rabbit unless you do something to become responsible for them. Whereas if you are walking down a path and you see a bunny and you kick that bunny or stab the bunny or otherwise commit an act of commission against that rabbit that constitutes abuse, you would be liable for animal abuse, whether or not the bunny was a wild rabbit or a domestic rabbit that had just gotten loose and was gallivanting about. Two other forms of more specific, sort of complex animal cruelty are animal sexual exploitation and animal fighting. Animal law, animal protection law in the United States largely exists at the state level or the tribal level if you're dealing with indigenous law. There is some federal animal protection law, but that's largely going to be a matter for the states, whereas there's a lot of federal law implicated in environmental laws and species level protection laws. And every animal protection law in the states has some sort of relevant exemption. Typically, that's going to be exemptions for things like lawful animal husbandry, lawful hunting, pest vermin control, protection of self, protection of others, protection of property. In some states, necessary or justifiable conduct, or humane euthanasia. So a good way to think about animal crimes are if you are engaged in an act of commission against an animal and you don't enjoy one of those exceptions, you are probably liable for animal abuse, assuming that you have the appropriate mental state to commit that crime. If you commit an act of omission against an animal that you are responsible for, and your conduct doesn't fall in one of those exemptions, then you are exposed to liability for animal neglect. Again, assuming you have the appropriate mental state. So let's talk about how this relates to wild animals. It's critical to know that there is no generic, but the animal was wild defense. We often talk casually in the United States about the fact that wild animals have less protection than some other animals. And this is sometimes shorthanded by people saying wild animals are unprotected by cruelty law. If you take nothing else from this conversation, please take away that that is not accurate. Wild animals generally are protected by cruelty law, but that doesn't mean they enjoy the same scope of protections as other animals. And the reason they're protected is you can't generally defend yourself against a cruelty charge by saying, but the animal was wild. You're going to get some potential complications when the animal is qualified as a pest or a vermin creature under the applicable statute, or in certain jurisdictions where predatory animals have even less protection than others. So you may have seen in the news over the last few years some fairly infamous cases out of Wyoming where coyotes have been hunted by people running them over with snow machines, or wolves have been captured alive and paraded around towns for the entertainment of bystanders. Uh, in both of the places where that occurred, one of the defenses that was raised was that coyotes and wolves in those areas of Wyoming qualified as a particular kind of predatory animal that had very few protections, and therefore running a coyote over with a snow machine wasn't an unlawful form of hunting. So in terms of the crimes you can commit against wild animals, acts of omission, i.e. neglect, the main question is going to come down to whether the defendant had sufficient control over the animal. If you have a wild animal in captivity, you almost certainly have sufficient control over that animal to be responsible for meeting their minimum needs. Um, so it implicates a range of actors from individuals who've captured wild animals all the way through to commercial enterprises. With acts of commission, the question is going to be even easier. It's basically, is there an applicable exemption? With sexual exploitation against wild animals, there are unlikely to be serious legal hurdles to prosecuting or charging that kind of case. With animal fighting, the major question is going to be, first, whether the animals in question are covered by animal fighting law. Animal fighting law typically covers a narrower range of animals than the rest of animal protection law. And so, for example, fish in the United States may be covered, depending on where you are, by animal protection law, but are rarely covered by animal fighting law. It's also going to be important to disambiguate animal fighting from hunting. If you live in a state where it is lawful to hunt wild animals with dogs, for example, you may need to disambiguate that activity from animal fighting. But that kind of argument is done routinely, and there are clear enough legal definitions for hunting versus animal fighting that that should be an overcomable hurdle. So let's talk about hunting. Generally, hunting is lawful. If you are hunting in accord with your licenses, your season for particular kinds of animals, a bag limit, i.e. how many animals you can hunt at a given time in a given season. If a hunter is abiding by those regulatory restrictions, their hunt generally will be lawful. But hunting can also be criminal cruelty. And this is an important thing to remember as well, because simply because the law allows someone to hunt doesn't mean they get to hunt using any method they want, or any time they want, or hunt any animal they want. And the hunting exemption, depending on how it's phrased, may only apply to lawful hunting. If, to go back to our exemption list, you are in a state that says it is animal abuse to cause an animal serious injury or to cause an animal to die, and then your statute lists exemptions, one of which is lawful hunting. If you are hunting outside of the season, if you are hunting without a license, if you are hunting using a weapon that is not lawfully allowed, then you are no longer lawful hunting you no longer enjoy that exemption and you are committing animal abuse. Similarly, if you have an exemption that describes certain types of hunting and you are hunting not in that manner, you are you are implicated by having criminal exposure to cruelty charges. Now, why might it be useful to apply animal cruelty law, animal protection law to unlawful hunting? One reason is that certain hunting requirements are meant to minimize the suffering of hunted animals. There are reasons people are not typically allowed to hunt animals using chainsaws, or slow-acting poisons, or traps in which the animal will die of exposure. It's because the community setting those laws decided that that was a degree of suffering they were unwilling to put up with. And they did not want to allow people to hunt in a way that caused that much suffering to animals. And this goes to why the lawful hunting exemption exists, why it is not cruel to hunt lawfully. It's not because society is saying that hunting animals does them no harm. It's not because society is failing to recognize that animals are injured or killed by hunting. That's the whole point of hunting. It's simply because society has decided that certain harms suffered by animals are acceptable under certain specific circumstances. It is effectively society saying, we recognize that this conduct towards a wild animal would be otherwise criminally cruel, but we will put up with it if you stay within these specific boundaries. That means if someone goes beyond those boundaries, they are liable for that harm they are doing to the animal. They are liable for that additional suffering they are causing. I want to quickly wrap up with, we've got a little over 2 minutes left. I'd like to quickly wrap up by giving you a summary of how we assess wild animal crimes. First, look at who the victim is and ask yourselves whether they count as an animal under your animal protection law. Look up your statute and see, does it specify that certain species count as animals? Does it simply say every living creature other than humans? Does it use some other phrasing? That will help you determine whether this wild animal counts as an animal under your animal protection code in the first place. Second, look at what the perpetrator did, what their conduct was, and match that up with what your animal protection law bars humans from lawfully doing to animals. If you're looking at an act of commission, you can apply that analysis to essentially any wild animal. If you're looking at an act of omission, you are going to need to determine whether and why the defendant, the perpetrator, was responsible for that wild animal victim. Did they have custody of that wild animal? Did they have control of the wild animal? Did they have ownership of that wild animal? And then finally, look at your exemptions and determine whether any of them apply. Was the perpetrator engaged in otherwise lawful hunting? Is this animal the sort that qualifies as a pest under your state law and that can be subject to pest control? Insects, for example, are wild animals, and yet state law generally allows them to be treated in ways that you can't treat other wild animals under the auspices of controlling them as pests or vermin. And by control, of course, euphemistically, I mean killing them or preventing them from reproducing. Was there a defense of self, others, or property issue implicated? Generally, the law does not ask people to allow themselves to be mauled by bears or allow a wild animal to carry off their beloved dog, or even to allow wild animals necessarily to damage their inanimate physical property. It's going to depend on how your law phrases that defense of self, other, or property exemption. And even if that isn't written in as an explicit exemption, certainly I would expect a defense attorney to raise a justification or excuse affirmative defense. That wraps us up with a whole 5 seconds to spare. It's been a delight getting to talk to you. If you have any questions, please don't hesitate to shoot me an email, drosengard@aldf.org. And I believe that my colleagues from our animal law program will probably have some more information and contact information for you. Thank you very much, and I hope you have a lovely day. Cheers.